Hello, I'm Rahul Bhardwaj, the President and CEO of the Institute of Corporate Directors. Welcome, and thank you for joining the latest in our series of webcasts discussing the governance impacts of COVID-19 health and financial crisis. Today, we're discussing privacy rights in the face of the pandemic. As organizations and businesses move to reopen, what privacy issues should boards be thinking about? And as data analytics are employed to keep people safe, how do we ensure that personal privacy continues to be protected? To discuss this, I'm very pleased to be joined today by Ann Cavoukian. Ann is the Executive Director of the Global Privacy and Security by Design Center and is recognized as an expert in privacy. Prior to her role at the center, she served 3 terms as the Information and Privacy Commissioner of Ontario. Welcome today, Ann. And to begin with, we're still obviously very much in the midst of this pandemic. As organizations respond, what immediate privacy issues are you most concerned about?
There is such a trust deficit right now, Rahul. For the past 2 years, actually, personal privacy has really been taking a hit. And all of the public opinion polls reflect enormous concern for privacy. I've been in this business well over 20 years. I've never seen the public opinion polls at the 90 percentile, 90% very concerned about their privacy, 92% concerned about loss of control over their personal information. So if you're on a board, if you're with a company, you have to ensure that your customers understand the lengths you're going to protect their privacy and secure their data. This is critical. So boards have to understand that privacy and data protection have become huge issues. And if you do it right, if you protect privacy strongly, using privacy by design, for example, you will gain a competitive advantage over the other guys who aren't doing it.
Now, so aside from the immediate concerns that you just started to touch on, do you see any long-term impacts of COVID-19 that may have an impact on our privacy rights?
Absolutely. And this is what concerns me enormously. The additional tracking and surveillance that governments are engaging in now as a result of COVID-19, and they're permitted to do it under emergency powers, under privacy laws. My concern is that this isn't going to stop after the pandemic stops. The pandemic's going to have an end date, but the tracking and surveillance may continue. So this is one reason I've been calling for very firm sunset clauses to be added to any additional tracking and surveillance undertaken by governments. You have to have a firm end date where all of the data collected thus far are deleted and are no longer collected. Then you can review it at that point to decide if you need to extend it or not. But you need solid end dates, sunset clauses. You need transparency associated with the data collection and full understanding of who's doing what and how you end it. You see, the fear is that privacy, which forms the foundation of our freedom, will continue to be infringed upon. Tracking and surveillance continues after the pandemic is over. And this has happened in the past whenever you have a major crisis. Like, look at 9/11. When 9/11 happened, after that, you had the Patriot Act introduced in the United States. Unbelievable surveillance. You had the Department of Homeland Security created. Unbelievable surveillance. And much of that continues to this day. That's what we have to ensure does not happen after the pandemic ends.
Right. So let's bring this inside the boardroom for a moment. Now, as boards and their organizations plan for what comes next, they may implement temperature checks or request medical information through questionnaires from employees, customers, and others. So what sort of safeguards should directors be asking their management teams to put in place in order to protect personal privacy?
They should ensure that any information collected this way is, first of all, strongly secured, that it doesn't go anywhere beyond the primary purpose of the data collection relating to your COVID status. It shouldn't go anywhere else. There should be very strong walls around this data. And you should have firm time limits on it. How long are you going to retain this data? It's not up to you to retain it forever. This is sensitive medical information. Health data requires the strongest privacy protection possible. And you have to ensure that the individuals understand why you're doing this and the lengths you're going to protect their privacy in this process. It will not be used for any other additional purposes. It will not be disclosed to any third parties. That's critical. I always tell people, beware of the unintended consequences of data collection, collected for one purpose that is totally legitimate, and then used for a variety of other purposes that extend well beyond the initial primary purpose of the data collection. I also ask boards especially to ensure that the companies they're working with, do they have a data map? I'm guessing no, most do not. A data map tracks what's happened to the collection of personal information that may have been consented to or authorized for the primary purpose of the data collection, but then it travels often throughout an organization in ways that have not been consented to or authorized. If you have a data map, you can track exactly where the information goes and if additional consent requirements or additional protections are required.
And just to follow that on for a further moment, in your experience, do many directors, do you think, have experience with the notion of a data map?
I was going to say I would hazard a guess at 0, but that's probably too low. But truly, it's that rare because companies rarely have a data map. So to expect the boards to have an understanding of how this works is even less prevalent. So just float that term. Every board should do this. Ask your companies, do you have a data map? I'm guessing most of the time you're going to get question marks in return.
Right. So let's go down this path just a little bit further then. So a board can ask management, could we please see a data map? And if there isn't one, let's discuss the importance of it and how do we move in that direction. Are there any other key questions that directors should be asking management around privacy at this time?
They should ensure that there's full transparency associated with their data collection practices. So not only should the individual be made aware of, and hopefully consent to the collection of their data, but there should be an understanding of what happens with the information. And that is rarely the case. When you have transparency, both the company and the data subject, the customer, know what you're going to do with their data. And the beauty of this is, I've advised a number of corporations and boards, and they've given me the best feedback. I always say, make the data you collect from your customers transparent and available to them so they can see what you've got on them. It's their right to know what information you've collected. What companies have told me is that they love about this is when they make the data available to their customers, the customers are then in a position and often alert them to mistakes in terms of the data collected, because the company's not going to know if something is correct or not. The data subject will, the individual to whom the data pertain, and they inform the company, and that way it increases the accuracy of their holdings. So it's a win-win. It works both ways.
So, Ann, I know that you advise a lot of boards. They'll retain you to talk to them about privacy issues. Is there a common theme that they bring you in to discuss?
There are two issues. One is, how much information do we have to give to the government? They feel that there's a compelling need to inform the government. And obviously, you have to do what you have to do, and your lawyers will advise you of the minimum that you are required by law to do. But don't go beyond that. That's what I always advise people. Do not go beyond exactly what you are compelled by law, required to give to the government. And make sure your customers know that. See, if you have that kind of openness with your customers, it enhances trust enormously. And so you tell your customers, we will not share your information with anyone. We'll only use it for the primary purpose intended that you have consented to. Where we are required by law to reveal this information to the government, we will advise you what we must by law provide to the government. That kind of transparency builds such trusted business relationships like no other. The other thing is, within your company, make sure you don't get pushed into using the information for purposes that were not intended. Don't get me wrong, I'm a big fan of marketing, but I would say privacy is not anti-marketing, it's pro-choice. People have to be able to choose how to use the information for marketing purposes. The marketers and advertisers will push the company in a particular direction. And I get invited to give the keynote at the annual conference of Canadian Marketing Association every year. And I always start by saying, I'm sure I'm the least popular speaker here today. And fortunately, they laugh and they say, well, yes, but we need to know what you have to say. So I always say to marketers, be upfront in your messages. If there's a benefit to the customer, something for them to gain, they'll consent to the use of their data for the purpose that you're suggesting. But it's when there's hidden uses that the individual customer later learns about, that's what creates the worst situation. So be transparent, make sure your customers know what you're doing with their information, to whom you're disclosing it, how you intend to use it, and you will gain a competitive advantage through that transparency and communication with your customers.
That's great. So I understand from boards then, a lot focused is on trust. We're looking at data maps, we're looking at compliance, and we're looking at transparency. Now, in the space of privacy rights, we're talking about rights, and rights, that can be a dicey area because obviously they can sometimes be in conflict with each other on various rights. In your opinion, is there a framework that organizations can use to balance privacy rights with the other important rights, such as, let's say, the right to health and safety, especially coming out of the COVID pandemic?
I personally don't like the language of balance because it implies a zero-sum mindset. The more you have of one interest, the less you can have of another. I often talk about this in the context of privacy versus security. So I hate the term versus because it pits one against another. And it suggests that the greater the security you have, the less privacy. And that totals to a sum of zero. Get rid of zero-sum thinking. Substitute positive sum, where you can have two positive gains at the same time. So that's how I want companies to think of privacy and other interests. Like I've been doing a ton of media interviews on the COVID thing and the tracking and surveillance and how it impacts privacy. So I would say you can have privacy and public health, not one versus the other. People have to have an understanding of how, when this information, your information is used, it can advance your health interests. All very important. You can do both. For example, Apple and Google partnered together for the first time, and they've created a wonderful contact tracing app that is totally private, totally secure, doesn't collect any of your personal information, is amazing, doesn't collect your geolocation data, but enables you to be notified if you're within a certain, I think it's 6 feet, of individuals who have tested COVID positive. It's amazing. It's a notification system as opposed to a contact tracing system, but it alerts you if you're in harm's way so that you can take care of yourself. But it builds privacy into the system seamlessly. It's brilliant. And I applaud Apple and Google for producing this and showing public health authorities that you can do this. It's not one versus the other, it's both. And they've made it open source so you can see what they're doing. It's amazing. So those are the examples I give. Of course, everybody wants public health, but it doesn't have to be at the price of privacy. You can and must do both.
That's a very interesting way of looking at it, Ann. I must say I agree with you. I think Canadians are going into a new phase where we have to get really good at doing both and that seems to be a part of the solution going forward. And before we sign off, I'm very curious, do you have any other further thoughts you'd like to share with us today?
I always like to remind people that privacy forms the foundation of our freedoms. You cannot have free and democratic societies without a solid foundation of privacy. It's no accident that Germany is the leading privacy and data protection country in the world. They're amazing. When I was privacy commissioner for 3 terms, a long time, 17 years, I attended a number of conferences in Germany. Each conference was started with a reference back to the time when, under the Third Reich and the Stasi police were controlling everything. When that ended, Germany said, never again will we allow the government to stifle our privacy and strip us of our freedom. And they've stood by that. That's what's amazing. So I always like to remind people, do not take your privacy and your freedom for granted. It may be difficult to retain, but it is definitely doable. And this is something we must do. We must live in freedom.
What a wonderful note to end our conversation today, Ann. Thank you so much for joining us today. And to our viewing audience, thank you for tuning in. Please look out for new installments of the series as we navigate this challenge together. Bye for now.
Thank you very much.